Today's true crime story is a little bit long, and possibly because I think judges should be stellar human beings and not act like the judge we're going to talk about. So, Erin Otis should have been the pride of the state of Arizona. She grew up there. She attended Marcos Deniza High School. In fact, when she was appointed to the bench as a judge in 2017, a group of JROTC students from a Tempe high school participated in her ceremony. She stayed in Arizona to earn all three of her degrees. There was a Bachelor of Science, a Master of Social Work, and then her law degree. She had a lot of honors while serving as a prosecutor in the Sex Crimes Bureau of the Maricopa County Attorney's Office in Arizona. She was awarded the second annual Paladin Award by Streetlight Phoenix, which is a residential treatment facility for underage victims of sex trafficking. Reads a civic alert from 2011 on the attorney's website. She was the Maricopa County Attorney Office's Prosecutor of the Year in 2010. It's hard work, all of that, earning 3 degrees and then developing a specialty in sex crimes. First, joining the court system in Arizona as a commissioner, and then she joined as a judge. And there's more. On paper, her resume is really impressive. When she began her career on the bench, she received positive reviews. Commissioners in Arizona are reviewed based on surveys that are done on jurors, litigants, and witnesses, or at least they were in 2016. Some of her reviews are publicly available. Right before transitioning from commissioner to judge, she was dignified, courteous, punctual, and impartial. Given what followed, that review is kind of ironic. Judge Erin Otis was the focus of broadcaster ABC 15's dishonorable investigative reporting in a 1-hour special. The facts that would become public from that investigation were, to say the least, remarkable, and they certainly don't paint a picture of someone who is dignified, courteous, or impartial. At the time of the investigation, she was already a Maricopa County Superior Court judge. She wouldn't be the first judge ever investigated. As you'll see in the remainder of the video, or in other videos, judges can get up to no end of bad business. You could be forgiven for thinking, like far too many other judges, that she was investigated for a DUI, or maybe for pushing her authority past appropriate bounds, for fraud, or even for theft. Well, no. What began her infamy was the wrongful things she said and wrote, and it was also conflicts of interest that cost taxpayers. What did this seemingly excellent candidate for judgeship do? There are several dozen examples of childish, mocking, and disrespectful behavior that just is never to be expected from someone who holds life and death decisions in her hands, literally. For much of her time as a judge, she sat in the criminal division, including presiding over death penalty cases. You would think the public, and certainly the people whose life is quite literally on the line, would expect that the person managing the courtroom would be grown up, wise, empathetic to the situation, and somber. Otis was not. To begin with, while she was presiding over a jury case, an unnamed juror explained her medical condition to the judge. You don't have to share the medical condition to empathize with how uncomfortable, perhaps even embarrassing, it would be to have to explain intimate medical details in a courtroom full of strangers. At least 2 of those strangers had no empathy at all. Court clerk sent the judge a meme mocking the woman. The judge's reaction was to laugh rather than oversee and correct the staff member who sent the email. The same court worker sent the judge other memes as well, including mocking a defense attorney's choice of pants. In that case, the judge seemingly began the inappropriate exchange, sending the court worker an email that said, quote, "You can see all the cellulite on her butt," end quote, and, quote, "not for trial or even ever," end quote. A meme followed the exchange, and mocking and laughing, behavior that just doesn't belong in a professional and serious courtroom. Do you question that? Imagine what the judge would do if attorneys shared memes about her cellulite with one another in the courtroom. Contempt charges. Contempt charges is what would happen. The behavior was often done during hearings and trials, some even during death penalty cases. The jokes and memes were not limited to one defense attorney and one juror, but included other attorneys, witnesses, jurors, accused people, and their family members. It included not only body shaming and mockery of sensitive medical issues, very little was off limits in Judge Otis's courtroom and to her court staff. The public is likely relieved that the meme-addicted court worker is no longer employed with the Superior Court. No information is available about whether or not she was terminated for this issue, terminated at all, or resigned. But she's not there any longer. But back to the judge. Though it was often done in open court, the judge's behavior was largely secret from the public, and that's often a problem. It was a definite problem in this case. A court clerk complained of the behavior. She says that staff used to hang the memes on the walls in the back of the courtroom, and that eventually those were taken down and put in an album referred to as a hate book. The charge was dismissed by the Arizona Commission on Judicial Conduct, but they sent her a private warning letter. No public information is available. No indication of what evidence was heard during the investigation or how deep the investigation into her conduct was. The commission works privately, so it's impossible to know what evidence they were actually working with. Even when she left the bench to pursue public practice, the commission apparently did not say anything about their findings to the state bar. It may be somewhat telling that the Arizona Commission on Judicial Conduct dismisses 97.2% of the complaints that it received in a 15-year period. 150 complaints sustained and 5,221 complaints dismissed, according to Dave Biscobing, who is the investigator for ABC 15. The commission is exempt from laws that make other state bodies transparent, state public record, and open meeting laws. Nowadays, across a good part of the world, citizens expect governments to be more and more transparent, more and more accountable. This is not how the commission operates. Commissions such as these literally operate on blind trust, despite the massive power and responsibility that they wield. To be completely fair, the vast majority of the complaints to the commission amount to little more than disagreements with legal rulings, and the commission cannot do anything to overturn or amend a judge's ruling. That is the purview of courts of appeal. However, in the interest of public trust, this commission's rules include some discretion. They are able to release more information and records to the public if it's in the interest of justice or in the public interest. Maybe they should do that. Members of the public can then have a little faith that investigations are actually happening, and they would also have better information about what their commission, and it is their commission, can and cannot do. Still, that private warning letter should have stopped the judge from behaving badly, right? I mean, if the commission is effective at all, their warning should have at least given the judge pause. One would think you would take all aspects of the job more seriously. It didn't, and that raises questions about whether the commission did an effective, in-depth job at all. A number of victims told the ABC 15 investigator that they were never notified of the investigation and so provided no testimony or input. Part of what the commission investigated was that the judge had communications with detained defendants without their lawyer present, which is also known as ex parte communication, and not allowed. The detention officer that worked in her courtroom was never interviewed by the commission. So what does a private warning letter mean for these folks? The State Bar then investigated a series of complaints about Judge Otis. By the time she was disciplined for her behavior, she had retired from that position and returned to the Maricopa County Attorney's Office. In letters from Otis's lawyers made public, we were told it was because she wasn't feeling fulfilled as a judge. It's hard to buy this when sources also say she became a commissioner because she was unfulfilled as a lawyer. She became a judge because she was unfulfilled as a commissioner. And well, we're back to the beginning of that loop. Her punishment amounted to an admonishment from the Arizona State Bar on October 20th, 2002 for her bad behavior from the bench. This is the minimal form for discipline that the State Bar had available to it. And for the months of investigation work, costs. She had to pay $600 in costs. The Bar Committee that did the investigation recommended probation, but the disciplinary committee that was to decide her fate decided against it. Without probation, when you look up Miss Otis's profile on the State Bar website, no mention of the wrongdoing will ever appear. Her behavior won't appear on the Commission's website, and it won't appear on the State Bar website. But hey, she had to pay $600. Oh, and the admonishment. Let's talk about the admonishment. The public record attached to that admonishment is 261 pages long. Part of it that deals with information before the commission and parts that deal with what was a still active death penalty case were redacted. There were two parts to the admonishment. First, that she contacted her new employer at the county attorney's office about potentially working there while she was still sitting on the bench. So what, you might say? Why is that important? This is an ethical breach because judges cannot have personal business dealings while still working as judges that are not disclosed. In this case, the public could know what happened and perceive that the judge had a reason to be biased toward the people she was trying to get a job from. It would be a completely reasonable presumption on the part of the public, and so that behavior is a no-no. The second part of the admonishment was for failing to supervise her court staff and for her unprofessional communications with those staff members. We've looked at that, so let's dive deeper into the conflict of interest issue. Because the conflict of interest that occurred while Ms. Otis was job seeking is far from the only conflict of interest. Let's scope out conflicts of interest a little before we go into the infamy of Erin Otis. Legal ethics looks at conflict of interest in two important ways: actual conflict of interest and the appearance of conflict of interest. An actual conflict of interest for a judge can happen in a number of ways. If, before they went to the bench, a judge worked as a defense lawyer or a prosecutor on a case, that judge would have an actual conflict of interest and should not sit and hear that same case. It's similar for lawyers. You can't prosecute previous defense clients or cross-examine them. Ethical questions like these can be subtle and complicated, but there doesn't appear to be anything subtle or complicated in this case. The appearance of conflict of interest is a bit broader. It deals with the trust that the public has in the legal system. As most lawyers and judges will openly admit, that public trust in the legal system is essential in a democracy. Lawyers and judges are to be held to high standards that keep that trust high as much as possible. This sort of conflict question asks what a reasonable member of the public would think if they knew the facts. Would that reasonable member of the public think that there was conflict? If that person would think that there was conflict, ethics would tell the judge not to hear the case or the prosecutor to hand their file on to someone else. It's more and more important to back away the more important the decision is. If, for example, both sides agree that a case should be adjourned for a week, that's a really minor matter and it's administrative in nature, and so the judge can sit normally. But if the judge is going to direct a jury in a case where the jury will decide whether or not a person lives or dies, the judge should steer as far clear of the case as possible, even if there is only an appearance of a conflict and no actual conflict. Someone who was a judge in the case, well, they shouldn't prosecute that same case after they step away from the bench. Was it a case where there just wasn't enough experienced prosecutors and no one else could possibly do that job? Not a consideration, as you'll see, but even if it were, the Maricopa County Attorney's Office has 1,000 employees, and those employees include very experienced prosecutors. So, Ms. Otis moves over to the Maricopa County Attorney's Office, and you would think that would end the issues. She's not a judge anymore, and so she's not doing the same harms as before. You would think, as we've mentioned, that maybe Ms. Otis would have become more reflective about the ethical obligations that being in such a privileged position comes with. But the same ABC 15 investigation revealed that there were multiple conflicts of interest in murder prosecutions that were caused by Ms. Otis and her boss's failures to properly screen for and then disclose conflicts or potential conflicts. These conflicts arose from times when she was Judge Otis and times after she left the bench. Part of the problem there seems to be that there was no easy way for Ms. Otis or for the county attorney's office to check on conflicts of interest, so it was not easy for her to check for actual conflicts. Another part of the problem is that it's not really up to the county attorney's office to decide the issue. It's up to them to disclose that, hey, there might be a conflict here to everybody involved, and then argue the issue and have it settled. They don't get to decide it themselves. Their obligation is to tell people what's going on. Well, the biggest issue for the state bar seems to be that she was inquiring into working for the county attorney's office before she left the criminal bench, and that gives rise to an appearance of conflict. ABC 15 uncovered more issues. When she was hired back on as a prosecutor, she went to the Capital Crimes Unit. That unit litigates death penalty cases for the county. Her office assigned her to 2 capital cases where she had previously played the role of a judge. Otis had transferred to family court sometime after she was being investigated by the commission, but she remained assigned to a case called Arizona versus Hernandez, likely because the judge who oversaw the jury trial should be the same judge that imposes the sentence. In that case, lawyers for Hernandez didn't raise any complaints about potential conflict, but it does appear that Otis was emailing and messaging the county attorney's office, who was prosecuting the case, about jobs while she was sitting as a judge. She also presided over a settlement conference and change of plea hearing for a co-defendant in Arizona v. Mason, another capital case. In that case, lawyers objected and filed a motion to have her removed from the case, and the county attorney's office fought the motion. They gave up after months of litigation and finally asked the court to transfer the case to a different county to be prosecuted. This was only after the judge, hearing the conflict issue, ordered an evidentiary hearing to hear more about the potential conflicts. And in Arizona v. English, Otis herself was removed from the case, but the Maricopa County Attorney's Office remained. The English case was messy for a number of reasons, but many of those have nothing to do with Otis or her conduct. According to ABC 15, the conflicts cost state taxpayers $58,000 in unnecessary spending after defense attorneys in those cases filed motions to disqualify her. According to them, the county attorney's office, which also funded by taxpayer money, also paid more than $25,000 for attorneys to defend Miss Otis during the Barr investigation. Admittedly, that amount isn't even at the higher end of what this kind of litigation costs, and it is reasonable to have independent counsel argue these cases rather than have prosecutors who have a personal interest argue them. Remember that adage, a lawyer who represents himself has a fool for a client? But given the facts laid out in this case, the taxpayer might have been much better served by a careful examination of the facts when deciding whether or not to have that fight to begin with. Although neither Otis nor County Attorney Rachel Mitchell, who was the county attorney at the relevant time, responded to emails and text messages from the ABC 15 investigators, they were able to question Miss Mitchell at a press briefing in November 2022. She denied that there was anything wrong with texting Otis while she was a sitting judge, who was at the time judging a death penalty prosecution, about returning to work for them without checking for conflict or other ethical considerations. She told ABC Otis had taken full responsibility for her actions. Quote, "What I will say about Erin is that she's an excellent prosecutor who dedicated her career to public service. Nobody's perfect. And when somebody does make a mistake, I expect them to take responsibility for it. I expect them to be held accountable for it. And I expect them to do better." The issue with this, of course, that at the time Otis rejoined the county attorney's office, she was mid-discipline proceedings. She was not taking responsibility for the behavior, but still arguing that she'd done nothing wrong, and she would not yet have been held accountable. Fair enough, people should learn and grow. Once they pay their dues, it's time to move forward, no issue there. In the public record, Otis asserts that the office knew of the commission investigation and likely outcome, that she had spoken about it with Ms. Adele, who was another member of the county attorney's office, but that Ms. Adele didn't take part in her interview. Ms. Adele seems to counter that. By February 11, 2022, Ms. Otis was on administrative leave with the county attorney's office after segments of Dishonored began to air. And only after segments of that program began to air and become public. At that time, Ms. Adele was, in fact, the head of the office. She says that her office never knew about the investigation, that no one in her office knew. She also claims that they did a very, very thorough background check on Ms. Otis before hiring her back into the office. But she wouldn't have seen anything on the commission website, and there was nothing about an investigation on the state bar website. She points this out in an interview she did with PBS. And surely they didn't talk to people who worked in Ms. Otis's courtroom, right? Because they would have known. Can the public be confident what a very thorough background check might mean in these circumstances? Or that Judge Otis was appropriately sanctioned for her behavior? And that the Maricopa County Attorney's Office now knows how to deal with a conflict of interest without wasting taxpayer money? Can the taxpayers be confident in any of that? If you're enjoying these videos and want more, don't forget to subscribe and turn on your notifications so that you don't miss any videos. Thank you for watching. We really appreciate it.